Namaskar, Adab, Sat Sri Akal, and a big hello to each one of you. In our series called Legal Literacy for Everyone, today's topic is the fundamental rights. As we all know, fundamental right actually constitutes the very essence of the feelings of our freedom fighters and those who framed our constitution. Fundamental rights actually exhibit two things. One, it was an occasion to make every Indian feel proud that he or she is going to be a free citizen and there is going to be a total equality, and that the bad memories of British rule were not going to be there. In addition, this was another occasion to set, correct, or improve upon the various evils that have persisted in our society from time immemorial. Now, talking about the historical aspect about fundamental rights, as early as in 1895, the first attempt was made through a bill called Constitution of India Bill, which was also known as the Swaraj Bill. It was actually the earlier phase of the Indian National Congress's movement. Later on, in 1928, the Motilal Nehru Committee also very strongly pitched fundamental rights for India. Later on, when the Constituent Assembly got constituted, the J.B. Kripalani Committee, which had good 63 members in that committee, they also actually very vehemently asked for fundamental rights to be incorporated in the Constitution. Now, we all know that our Constitution makers were actually very much impressed by three international developments. The first one was the 1689 Bill of Rights in the UK. It was followed by the Bill of Rights in the US 1789 and the French Revolution, which actually came out with the rights for men again in 1789. So these were the three international events which were very much in the minds of our constitution makers, and the immediate trigger came from the Universal Declaration of Human Rights on 10th of December 1948. So this is how the fundamental rights made a very, very important part of our constitution. Now, talking about the fundamental rights, there are from Article 12 to 35 of our constitution, there are 6 fundamental rights. And in order to narrate them all, the first is the right to equality, okay, which means equality before law and equal protection of law. And these articles are Article 14 to 18. Now, from Article 19 to 22, we have the right to freedom. So there are various freedom like freedom of expression, speech, movement, etc. Now, moving forward, we have rights against exploitation, which is covered by Article 23 and 24. Next are the rights for freedom of religion, which is Article 25 to 28. And then comes the cultural and educational rights, which are covered by Article 29 and 30. And last but not the least, and probably the most important right, is the right to constitutional remedies, which is covered by Article 32. And to not forget that there used to be a 7th fundamental right also, which was the right to property, but it was removed by the 44th Amendment in the year 1978, and right to property is no more a fundamental right, but it is now a legal right, and it is covered by Article 300A of the Indian Constitution. So this is the whole scheme of fundamental rights. Now, what makes the fundamental right much more important than other articles of the Constitution is that in case of the violation of fundamental rights, people have the right to approach the Supreme Court straight away, the Supreme Court and the High Courts of various states straight away, which is quite unlike the situation or the position as regards the rest of the articles or rest of the laws that we have in India, wherein an individual has to first approach the subordinate court, and by way of the appellate jurisdiction of the higher courts, it can reach out to the high courts or the Supreme Court. So this way, it is a very important right that has been given to individual, and this right is actually exercised through the writ jurisdiction which is specified under Article 32 and under Article 2 to 6 with respect to the various high courts of the states. Now, under this writ jurisdiction, there are 5 types of writs, very important writs, which can be issued by either the Supreme Court or the High Court whenever any individual who comes with a complaint about violation of fundamental rights. Now, these writs are writs of habeas corpus, certiorari, mandamus, quo warranto, and prohibition. So these are the 5 types of writs that the Supreme Court or the High Court can issue to restore, protect, or safeguard the fundamental rights. Now, moving forward, one very important question arises: can these fundamental rights be amended? Now, this has been a very hot debate right from our independence, and the earlier judgments like, say, Sankari Prasad versus Union of India or Sajjan Singh versus state of Rajasthan. Now, these 2 cases were the earlier ones. The first one in 1951 and the second one in 1965, wherein the Supreme Court held the position that the fundamental rights can be amended. Now, there was a lot of hue and cry, and in 1967, in the Golaknath versus state of Punjab, the Supreme Court held that the fundamental rights cannot be amended. Now, this was it was a novel position because it actually mentioned that the legislature had no right to change the fundamental rights. But then in the year 1971, through the 24th Amendment, it was actually established that the fundamental rights can be amended. Now, this again led to a lot of commotion, and later on, in the Keshwanand Bharti versus State of Kerala, which is one of the most important judgments about the Indian Constitution, it was decidedly held by the Supreme Court that yes, the fundamental rights can be amended, but the fundamental rights cannot be amended in such a way that the basic structure of the Constitution gets negatively impacted. So it was like a Lakshman Rekha, drawn by Supreme Court, wherein the legislature or the executive would have to be bear in mind that they can certainly look at amending the fundamental rights, but while doing it, they have to make sure that the basic structure of the Constitution does not get disturbed. And ever since the Keshwanand Bharti judgment, the law has been like that. In the year 1981, in the Minerva Mills case, Supreme Court reiterated this stand, and this is how we are presently placed. So fundamental rights can be amended by the legislature, but while amending them, it has to be made sure that the basic structure of this Constitution, which talks about justice, liberty, fraternity, equality. Now, these aspects of our Constitution, they can't be tampered with. Now, moving forward, I would also like to bring to your notice that although fundamental rights are sacrosanct, but there are some, exceptions to it. To name a few, in Article 14, although we talk about right to equality, but there are certain provisions in Constitution which give a different kind of position to various individuals. For example, the President and governors of the various states and the President of India, they enjoy immunity during their, while they hold the office. Similarly, the discussions that take place in the Parliament, the members of the Parliament are also protected in terms of whatever discussion takes place within the Parliament, and they can't be held responsible or accountable for that. Now, similarly, moving forward, we find another exception in the articles related to freedom, wherein the freedom of expression or freedom of movement or freedom to make associations, etc. The executive can put reasonable restrictions on these freedoms. Now, what is a reasonable restriction is better left to the courts, and we have such a case law wherein a few restrictions were found to be fine and a few restrictions were found to be too excessive. Similarly, under Article 21, which talks about right to life and personal liberty, there have been, hordes of cases wherein we find that some courts have found that the transgression of the executive by way of the preventive detention laws. Now this preventive detention law, before we move forward, is an exception to say Article 21, because it talks about apprehending or arresting somebody without a charge. In apprehension of crime, if somebody is arrested, it is known as a preventive detention. And very sorry to be sharing that right since our independence, starting with the 1950 preventive detention law, which expired in 69, then in 1971 the Indira Gandhi regime came out with the MISA Act, which is the Maintenance of Internal Security Act, which lapsed in 78. Then in between we have had Kofe Posa, we have had TADA, you see, and various such preventive detention acts. Presently we have National Security Act 1980 and UAPA 2008. Now these are the two preventive detention acts which actually are causing a lot of consternation in the country, in the sense that they are often found to be getting misused. And together with these, Section 124A of the IPC, which talks about the offense related to sedition, is again being debated upon, and there are voices being raised that this colonial law needs to be removed from our statute books. Now, having gone through all this, I would quickly take you through some landmark judgments about fundamental rights, wherein the Supreme Court in some cases interpreted the law, and in some cases it found that the executive had gone, or the legislature had gone much beyond its brief and had actually made laws which infringed upon various fundamental rights. Some important cases are the Maneka Gandhi case regarding right to travel, or maybe the A.K. Gopalan, the earliest one. This was 1951 case. Together with that, we have the habeas corpus case during the 1975. Then in 1973, we already had the Keshwanand Bharti case. And if I talk about the recent ones, in 2012, the Justice Puttaswamy case actually came out with the clarity about the right to privacy, and in 2017 again the Justice Puttaswamy case actually overruled the position taken by the apex court in the habeas corpus case of the the dubious those emergency years of 1975 to 77. So in totality we can say that fundamental rights actually exhibit the very essence of the pride, the dignity, the equality, the fraternity amongst the Indian individuals, and the constitutional design is such that the Supreme Court has been made the protector of these fundamental rights. And although there would be some tension between some laws not being up to the mark and some laws going beyond their briefs, but I'm very sure that with a vigilant public opinion and media and a very strong and independent Supreme Court being there, the fundamental rights would always be protected, and Indians would have a very, very happy and wonderful life in this vibrant and this strong democracy that we have in our country. With this, I would like to again share that kindly promote this video. We'll be coming out with many such videos on various aspects of laws and our constitution and related matters, and it would be pleasure sharing these things with you. Please take care. Namaskar.